This is a lecture on the basics of property law as it pertains to land surveyors. So for an introduction, property law and title law are two classes that are taught in law school. Title law comes after property law. Property law includes a wide range of things that surveyors are not really concerned with, such as landlord and tenant rights, personal property, other things besides real property. So title law also looks into things that don't pertain to surveyors very closely, like if a deed was, or a security deed, a loan, a mortgage was properly executed, if it complied with federal lending laws, national security laws, that sort of things. Estates can be contested, were all the heirs properly taken care of. All those things are studied and need to be studied in those classes, but they don't pertain to surveyors. We'll study the legal aspects of those laws which do affect the practice of land surveying. So for some foundations, we're going to go through some basic terms and expound on them a little bit. There are concepts that land surveyors need to be familiar with. First of all, what is real property? Real property is anything that's permanently attached to the earth, including the land. Real property rights extend below the surface of the ground, and they extend up above it. So what's right over your property is yours. Although above a certain elevation or certain height, you don't really exercise dominion over it because you have air rights where airplanes can fly and that sort of thing. This also gets into some interesting rights and disputes over drones and that sort of thing. But to think about what's real property, just for a little elaboration, I use the example of a basketball court. If it's concreted in the ground where it can't be picked up and moved, it's real property. If it's on wheels and you can go load it in a truck and haul it off, it's not real property. It's not too complicated. So we talk about real property in the context of ownership. Who owns what? That's what people think surveys do, is they define the boundaries of what you own. So ownership in the sense of surveyors is generally equated to having title. Now let's talk about title for a minute. The first thing that probably pops in your mind is the title to an automobile. Let's say you don't have a loan, you have a title. Title to your automobile is registered through the Department of Motor Vehicles, and they keep track of who owns what. That way they can call in a tag number, law enforcement can, and figure out whose car it is. Title to property is a totally different concept. There is no managed instant recordation of who owns property. To know who has title to a piece of property requires an examination of the records. Basically, there will be several deeds for a certain piece of property that are previous owners. Title is held by the last person to whom property was deeded. That's a simplistic legal theory. In that, we were just referring to previous owners. That's the chain of title. That's from the very first person that ever owned it, person or entity, to who currently owns it. Chain of title would be referring to the chronological listing of recorded documents that make up a history of conveyances for a particular parcel of land. Not only would it include each deed from one owner to the other, but every transaction that owner made. So if John Doe owned that property for 20 years and he granted the gas company an easement and he took out a mortgage, those documents would be recorded and they would all be part of the chain of title for that parcel of land. It can get complicated because the property is subdivided. If John Doe owned 20 acres and he granted a gas line easement and then it was subdivided into 20 lots, you have to figure out which of those lots the gas line applies to, where the gas line lies. So it would be in the chain of title of every lot, but it wouldn't affect every subsequent lot. So we need to talk about interests. So every element of right to a piece of property is an interest. So if you own it, you have the best interest. You have ownership interest. You have title to it. But other people or entities can have interest in it, such as if an easement has been granted to the gas company or the power company, they have an interest in your property for the purpose of installing and maintaining a gas line or a power line. If part of the property has been leased to somebody, they have an interest in that part of the property for the purpose of the lease. Some people might think that they have title free and clear, but even in that instance, the tax commissioner has an interest in the property, because if you don't pay the property taxes, they can sell it at the courthouse steps after going through the proper tax foreclosure procedures. So even they have an interest. So a lot of people have interests in your property. And interest doesn't mean that you're interested. It's a noun that means any element of right to that piece of property. In a conveyance, you have a grantor, which is the term for the person or entity that is conveying a parcel of land or conveying an interest in it. That's the grantor. And deed records are usually indexed both by the grantor and the grantee, which is the person that is receiving a parcel of land or an interest therein. So in the case of the easement examples, the gas company would be the grantee of a gas line easement. If John sells to Bill, Bill is the grantee of the property in that deed. So in these documents, they're all subject to the statute of frauds. Statute of frauds is a term that comes from English common law, which is where our laws in the United States came from, except for Louisiana, which have upheld a French legal system. But the statute of frauds basically means that for a document or a transaction, any kind of dealing with a piece of property, it has to be written and signed. It can't just be verbal. So if John says, Bill, for 20 bucks, I'll sell you my property. Bill gives him 20 bucks. Bill thinks he owns the land. He didn't, because there's been no proper written document. That's to prevent fraud. At least that was the intent in the British common law. Is how it got its term. Now, the statute of frauds has been codified, which means it's been written down into law, and it's in every state and the federal law books for the statute laws. In order to be fully enforceable, it doesn't just have to be written and signed. Each state has document and real estate records laws. So in Georgia, a document needs to be signed by the person who owns the property. It would be the grantor. Needs to be witnessed by an independent third party, not a relative, not a sister or a wife, but some person walking down the street, co-worker, etc. And it has to be notarized by a notary public. Notaries are just common people. There's no election. They go to the clerk of court and register to be a notary. They do a background check. They get certified as a notary, and they're subject to the notary laws. So those are things that need to happen for a document to be valid, all kind of extending from the statute of frauds. In each document in this chain of title, something has to describe what the property is. So if Frank owns 10 pieces of property and he says, I'm selling Bill my property, my piece of property, well, which one? That's ambiguous. So it can be as simple as the eastern 3 acres of my farm, or the southern 10 feet of my lot in the city. But usually they're very descriptive, and often they're based on surveys. They're used to describe the property. That's basically the essence of it. And legal descriptions bear a much deeper discussion, which we will later. In particular, one of the most important legal descriptions for the surveyor is the vesting description. And that means it's basically the current description. It's the legal description in the most current deed in that chain of title for a piece of property. So it's the word vest means to instill or provide. So it's provided the property to the current owner, or it has instilled the current owner or vested them with this property. So we look closely at the vesting description because that's the one that has the most importance in the hierarchy of title law. So the most common form of deed, one that you'll find the most in the chain of title, is the warranty deed. And of course, deed is just generally a document that conveys property, generally the ownership, and not just an interest, but the whole interest from one party to another. A warranty deed is set apart because it means that the grantor is warranting that they own the property and that they can sell it. It typically includes some language that makes it a warranty deed, whether if it's in the title or not. Something like the grantor will forever warrant and defend the title of said property. Another common deed is a quitclaim deed. Now, a lot of people have questions and curiosities about why you would sign a quitclaim deed. Quitclaim deed simply means I'm quitting my claim to the property described in it, whatever that may be. So if I own property and have full title and I execute a quitclaim deed to person B, well, I've granted all of my interest. I've quit all of my claim to that property to person B, and I don't own it anymore. But if I were to sign a quitclaim deed in the description of the property is the county courthouse, which I don't own, the county owns, then that deed's really of no effect. So all it is doing is saying whatever I own, whatever interest that I have in this piece of property, I'm conveying it to the grantee of the quitclaim deed. Now, there are a lot of good reasons to do this. Some of them are a mortgage company or a bank, once the loan's paid off, that interest has been extinguished by the fact that the loan's been paid. They'll execute a quitclaim deed to the owner, to the grantor of the loan. So that's a very good function. The Truist Bank would sign a quitclaim deed to your house that they don't have a lien on it anymore. Another instance would be if there was a faulty legal description and they didn't really know if you conveyed all of the property or not. They might get you to sign a quitclaim deed for a corrective legal description that says, hey, whatever I might own in this, I'm conveying it to the grantee. Also used to clear up claims of estates, to where if an heir pops up and they say, hey, I didn't get my share of this, I was left out, and there's some sort of settlement made, that heir may sign a quitclaim deed to the new owner that says, I'm not claiming any more. I'm not claiming any interest in your property anymore. I quit. So that's kind of where quitclaim deeds came from. A security deed, also known as a deed to secure debt or a mortgage, some states it's called a deed of trust. So the function is basically, I'm taking out a loan against this piece of property. I'm using it as collateral. I'm putting on notice that I owe, and I'm just using Truist Bank as an example because they're headquartered, or got the stadium there in the Cobb. So the security deed means, it's secured by this loan. So I can't just go sell it. I still owe money on it. So the bank needs to be taken care of before I can sell it. And so that's how banks get involved in transactions. Another way of looking at it, and particularly in the states that do the deed of trust, like Tennessee, basically the way the language reads is you deed your property to the bank, and the bank allows you to live there as long as you make the payment. You quit making the payments, they kick you off of their land. So that's essentially what happens in Georgia with a security deed or a deed to secure debt. Except it's not spelled out quite that harshly. There is a trustee appointed in these other states that's in charge of making sure that you make your payment and that the bank treats you right. The trustee is often the closing attorney because they just have to be a valid legal entity or person that can serve in this third party where they're not biased towards the bank or the property owner. They're just there to make sure that everybody is trusted to do what they're supposed to do. So a deed to secure debt, or a security deed, loan deed, mortgage deed, deed of trust, just basically means there is a loan against the property. Now, from a surveyor standpoint, we really don't care. You take out a loan on a piece of property and then you pay it off, or you refinance it with another bank. The first bank's going to sign a quitclaim deed. You're going to execute a new security deed to the second bank, and then later on they sign a quitclaim deed when the loan's paid off. That doesn't change anything that we're doing. There is a rare exception. Some banks will require a new survey for a loan. They may incorporate that new survey into the legal description for their security deed. Whereas the vesting description may have an old survey that's kind of clumsy or outdated, or it's kind of crude, or it doesn't reflect some changes that have been made, like some property that was sold off. But the legal description in the security deed may be current. It may provide a different survey altogether, or a different legal description altogether. So I don't encourage looking at every security deed for the subject property that's being surveyed. But if there's a question, if you're wondering, sometimes, 80% of the time, maybe more, it's non-productive. It's just got the same legal description that the warranty deed used. It's probably more like 90 or 95% of the time. But sometimes you'll get lucky and find a legal description in a security deed that calls for a survey that answers a lot of questions. An estate deed is basically kind of a blend of a warranty deed and a quitclaim deed, depending on the estate. The estate's saying basically whatever we own in this piece of property, we're deeding it to you as an exercise of the estate. An estate is when someone dies who owns their property, their estate does. And the estate's kind of this quasi-legal entity that exists for the purpose of disposing of the deceased person's property, whatever it may be, real property or personal property. So, somebody's estate can sell their cars, liquidate their bank accounts, sell their property, can do a lot of different things. Sometimes the estate does not want to warrant title because maybe they think that Uncle Jed might have had an illegitimate kid from when he was in the Army. And so they don't want to warrant title to that. These things come up. But the main thing is they call it an estate deed, or a deed from estate, or an executor's deed, meaning the executor is a person that's appointed by the probate court to be over an estate. Sometimes they're called an executor's deed or an administrator's deed. Sometimes a will has an administrator. But that's the purpose, is to let you know that this is just not an arm's length transaction between person A and person B. Person A is dead and their estate is conveying it. So that's just to put people on notice that happened. Does it have an effect on surveys? Not really. We're just still mainly looking at the legal description. A timber deed. Now, let's go back and look at real property. The basketball goal that's cemented into the ground is real property. How about the oak tree behind it? Yeah, it's real property, isn't it? You can't just pull it up. What if you just want to sell the timber off your land, but you don't want to sell your land? Well, that's where a timber deed comes into place. Now, surveyors are generally not concerned with timber deeds because normally it's either they just use the legal description, or sometimes they use the vesting description in the timber deed. Sometimes it's they do something totally different. Sometimes they only they've only selling the timber off of the east half, or the eastern 40 acres, or the property east of the creek or north of the road. So still, that doesn't affect the property description that we're surveying by. Sometimes, though, timber company may have a survey done. If the legal description is very poor, then they may get a survey done of what they're buying the timber on, and so there may be a survey that's entered into the chain of title. So you need to take a glance at timber deeds and review them, but often they really don't mean anything to the surveyor. A timber deed is basically a lease because you're giving them a temporary right to get on the property to cut the timber off. The timber being part of the real property, so they have to distinguish it that way. There's also some tax ramifications as to how the timber is taxed once it's taken off, and a timber deed triggers a series of tax actions with the tax commissioner's office. It's usually for a certain period of time, or when all the timber's been cut, or there might be some triggers, like if the timber goes above a certain price on the open market, the timber deed it's canceled, or and the people get some of their money back or something because the price is going up. But for the most part, it's not something that surveyors need to get too concerned about, but they do bear looking at. A right-of-way deed is called that, even though it's conveying property, much like a warranty deed or a quitclaim deed. But it's letting people know that this is for the specific purpose of building or widening a road, a sidewalk, or some other kind of public transportation route. They can be very simple, like a standard rural road right-of-way deed. May just be a certain distance from the center line. 30 feet is the most common. 30 feet from the center line, 60 feet total. A new DOT project is not going to be based on some uniform width. It's going to be, the right-of-way boundary is going to be based on the engineering of that road project. So they'll determine where the cut slopes and the fill slopes are going to extend, drainage structures, storm drainage or erosion control features, and they're going to have a very irregular right-of-way boundary that accommodates the engineered improvements to that road. And also they'll often have not just fee simple being sold or conveyed or taken by the state DOT or the city or the county, but they'll have easements that extend outside the actual right-of-way boundary that are elements of title that'll need to be shown on a survey. Most common will be a slope easement, where the state doesn't want to own that land, but they want to lay a slope back on it. Sometimes it's a construction easement where they can get in and fix something or build something. Sometimes it's a construction easement to build a driveway, where they're redoing the driveway access per the engineered plans. So there are a lot of different easements that can go along with the right-of-way deed, not just the fee simple right-of-way that's being conveyed. And so what is an easement? An easement is just a right by one person or entity to exercise some right over a certain piece of property. So the most common examples could be, let's look, staying on easements for a minute. Easements could be for the purpose of constructing a power line, burying a water line or a gas line. It could be even a negative easement where you agree not to have chicken houses on your property to somebody else. So it's not just the right for somebody else to do something over your property, but where you give them an interest in your property besides ownership. Another document that will show up in a chain of title is a boundary line agreement. A boundary line agreement is going to be recorded, indexed as a boundary line agreement or just an agreement, but it's to where adjacent properties, their legal descriptions don't exactly match. Efforts have been made, a boundary has been established that both parties agree to, that's not exactly the same as what's in their vesting description. So a formal agreement that would be signed, notarized, witnessed, etc., would be recorded that says from here on, the boundary between party A and party B will be as follows. And it's usually going to cite a survey, either by a long legal description or an actual survey that gets recorded or recorded along with the boundary line agreement. So this is the most common way that boundary disputes or boundary uncertainties that pop up are resolved. So how do we own property? So fee simple means, let's back up, the word fee in this case does not mean that it's a cost or a penalty. It's not an application fee, parking fee, technology fee. It's a different word altogether that comes from Old English that just means the ownership. I own the fee in that land, for example. So the person who owns it is maybe the property owner. Another synonymous term would be the fee holder. I hold the fee to that land. And so the owner of property, and we talked about this a little bit earlier, but it means that the owner has possessory rights. It means they get to occupy the land, they get to cultivate, or simply exclude others. The right of exclusion is one of the principal elements of private property ownership is that it's yours. You can tell somebody to leave or not to come on your property, and they're not supposed to, or they're trespassing. Another interest is a lease. Obviously, that's where someone rents some or all of the property from someone for some purpose. Usually that's something that a surveyor is not very interested in. Sometimes it is. Sometimes a person wants to know where they're having their property surveyed and they've leased part of it to somebody else. They need to know where the extent of that lease is. So the lease may have a legal description, should have a legal description that describes what's being leased, and it may be only a portion of the property. So if we're just surveying the fee of the property, we don't care where the lease boundary is unless the client asks us to. Now, sometimes leases are for short periods of time, 1 year, 3 year, 5 years. Sometimes they're for 99 years or for 100 years or 200 years because one party can't actually sell the property, but they want to have the same effect. So they lease it for much longer than anybody will be alive. Sometimes these lease boundaries are very important because if you have a very long-term lease interest, like 99 years, then your rights probably include being able to improve that land, to build something on it, to clear it, to do things with it. And so you need to, leaseholders may borrow against that. So if you've got a 99-year lease, a bank will give you a 30-year loan because you own it for 69 years after that loan's over. So they'll loan money on it just like you own the property. And that can be to build a house, build a building, build a park, whatever. So lease boundaries are something that would be handled case by case by a surveyor. If it's a house in a subdivision and they've leased it to somebody, that lease is probably not recorded. Leases usually just get recorded and entered into the chain of title when they're of a long duration or just a portion of the property, or when there's some other important purpose that makes it a good idea to record it. Now, anytime that an interest has been conveyed or has created, that's a cloud on title. That means that it's something that prevents me from having full, clear title to a piece of property. Now, in common sense exercise of this, it does not extend to the tax commissioner having the right to foreclose if you don't pay your property taxes. But it does mean like an easement. That's a cloud on the title. It doesn't mean it's an unacceptable cloud on the title or that it fatally destroys the property and can't be sold, but it's a cloud that has to be looked at by a prospective buyer or a title examiner. Clouds on title are usually something that surveyors are interested in. We're required to show easements, for example. If there's a deed restriction or something in a covenant, restrictive covenants like in a property owners association in a subdivision, that's a cloud on the title. It tells you, it restricts your possessory rights and what you can do on it. So these are written title clouds that often come up and become a survey matter. Also, unwritten situations or circumstances like adverse possession or a prescriptive road right-of-way are not written into the chain of title, but they can exist, and when they are discovered, they create a cloud on the title because they are something that restricts the fee holder's full use of the property. There's also something in the realm of chain of cloud on title that surveyors need to be really acutely aware of, and that's if a survey erroneously overlaps another piece of property. Not just a difference in professional opinion on where the line is, but it's just basically an error. And party A's survey shows that it owns part of parcel B, and it's just wrong. Well, that overlapped portion has been clouded now by party A's survey. Now, if that survey is unrecorded, nobody knows about it, it's probably not really a cloud on title. But if party A comes out and says, hey, I own part of that property, here's my survey, then that begins to affect and be a cloud on the title. If that survey is recorded and put on public record, it definitely is a cloud on title. And that and a few other acts are known as slandering title. So if I willingly sign an easement to Georgia Power Company, I now have a cloud on the title, but they've not slandered me. I willingly conveyed that interest. But if I survey and overlap somebody else's property and now it's clouded, I've slandered the title to their property. I've damaged them, and they can come after me legally. So it's another reason to make sure you get your boundaries right when you survey property. Adverse possession. This could be a very lengthy discussion. We'll try to keep it short. There's a good discussion on it that expounds on it well in some of the law text that's in the reading assignment. To kind of brush over it, it hits some surveyor related points. My professor called it legal stealing. That's how party B can steal part of party A's land by meeting some conditions. Basically, that means that I'm possessing somebody else's property. So that's adverse to them. It's not in their favor. I'm adversely possessing part of somebody else's land. If my occupation and my rights and my use, not my rights, but my use, my activities extend over onto somebody else's property, that's adverse. So, according to the law, if I do that for a certain period of time under certain conditions, I can wind up being the owner of that portion of the other person's property by the laws of adverse possession. This is why surveyors are charged, as we'll see in the technical standards, to display any form of possession and occupation along property lines, because we need to put our clients on notice that, you know, your adjacent owner is possessing over on you. Their fence is over on your property. If you don't do something about it, they could have a good legal claim under the law under adverse possession. So here's where a lot of confusion comes in. A lot of property owners may get on the internet and find out about adverse possession. I think they do a better job now, but for years, realtors were simply told, if you possess somebody else's land for 7 years, it's yours. The boundary line moves to the extent of the possession. So I personally have had realtors argue with me that some encroachment was not an encroachment, but the property line moved because it had been there for 8 years. And surveyors are charged with establishing where the title boundaries are and identifying and showing elements of possession. We can't move a property line. In that same context, there is no adverse possession officer. There is no adverse possession police. There is no office of the Fulton County adverse possession claims. In order for the adverse possessor to gain title to this property that they have adversely possessed, they have to sue the rightful title holder for title. And most of the time, if the elements have been met, the court will order, yes, this property now belongs to the adverse possessor. And that changes the ownership of the person who you might call a victim in that case, but the person who lost the property through adverse possession. So adverse possession is real. It's definitely in the Georgia law. It's something every surveyor needs to understand. It'll be in licensing exams, that it has to be open, notorious, hostile, and most of the time under a claim of right or color of title, which means, you know, I can't, without color of title, that means color of title is a deed, usually a deed that says I own some property and I just wandered off the reservation. I got on somebody else's property. So I did it in good faith. I wasn't fraudulently trying to steal it. I thought it was mine. I was acting in good faith. Come to find out though, I've spent money on this. I've spent time on this other property. I'm claiming it now. So those things have to take place, but it takes the court or the two parties to agree to move a property line. Adverse possession does not move the property line the way surveyors survey it. Let's talk about easements for a minute. So the simplest, best form is an express easement. That's where the grantor conveys an interest in their property to the grantee. It might be a 20-foot strip for a water line easement to the local, to the city water department. So that's going to be signed, executed, witnessed, notarized, and recorded. It becomes an express easement at that point. Each easement needs to have a legal description, just like any other document that conveys interest in property. And it may be an exhibit drawing that shows where the easement is. It might be to the power company, it might be a blanket easement, which we'll talk about in a minute, but it's still express. It's something that's written and entered into the chain of title. Implied easements will likely be discussed on licensing exams. They are not express easements. They don't necessarily show up in the chain of title. The most common example is when there's a subdivision plat recorded where a common grantor owns this chunk of land and he or she is subdividing it into a number of lots. And they show roads that have been built and created, and maybe they show drainage easements, they show common areas and green spaces. The law says that the person who buys one of those lots is understood to have an implied easement or a right in the roads, the drainage easements, the common areas, equally with all the other lots in the subdivision. So that's implied. So, you know, a legal description for a deed in a subdivision in that situation may say all that tract or parcel of land, land lot so-and-so being lot 55 of Huntington, as recorded in Plat Book 99, page 5. And that's all. That's all it really needs to say. But what it's also implied to say is, also conveyed are the rights to travel the roads within Huntington subdivision and to enjoy the common space and the green belt and to have function over the drainage easements in Huntington subdivision. So those are things that are implied. Another form of implied easement that may well show up on an exam is the implied easement based on prior use. So let's say that I own 2 acres and I've got a house in the back of the property. I cut off an acre with the house and sell it to somebody, and they get to it by a driveway that goes through my front acre that I've kept. Well, if the legal description only describes the acre, you know, beginning at this point, going around here being 1 acre, or as shown on this survey, it's implied that I'm also granting them the right to use the driveway. Now, that's bad because the terms of maintenance are not spelled out. The width of that easement for that driveway is not spelled out. Is it just on the surface of the driveway? Do they have the right to mow the sides of it? Do they have the rights to install cable television wire down the side of the driveway? None of that's spelled out in an implied easement by prior use, but it still legally creates an easement that is implied and not expressed. Now, that's something that we wouldn't declare as an implied easement in that case. We would just show the driveway on the plat and let the attorneys and the parties understand that's where it is, and then they have to decide, do they call it an implied easement? Do they want to try to get some sort of easement agreement signed by the parties? Something that comes up at that time. Okay, similar to adverse possession is a prescriptive easement. The difference between adverse possession and a prescriptive easement is basically adverse possession affects and goes after the fee. The adverse possessor gets to own the property if they are successful in an adverse possession court case. A prescriptive easement is just that, it's just an easement, but it's acquired the same way. You know, the use has to be adverse, has to be open, notorious for a certain number of years, and it doesn't necessarily have to be under a color of right or a color of title. It can just be that, you know, in some circumstances, like in Georgia, if you have some color of title, 7 years, you thought you had an easement, maybe you're good. But if it's not, then it takes 20. So a trespass can continue to be used and ripen into a prescriptive easement. Now, just like adverse possession, where people think, I've been mowing that yard for 7 years, it's mine. People will say, I've been using that road for 10 years. You can't stop me. I've got a prescriptive easement. I looked it up on the internet and I talked to a lawyer. Well, just like adverse possession, that prescriptive easement doesn't really become valid until a judge says so. So people will say to a surveyor, show that as my prescriptive easement. Well, we might show it as a road, a driveway, or trail, or whatever, but we don't want to give somebody the impression that they have more legal rights than they have. So a good general rule of thumb is you need to have an express easement, need to have an easement shown on a plat that's recorded, that's all been vetted by the by the title exam process, to where if the property owner that easement crosses comes out and accuses you of trespassing and calls law enforcement, you need to be able to say, I'm not trespassing and here's why. So prescriptive easement is not a piece of paper that you can pull out of your pocket. Blanket easements are express easements, but the legal description is blanket. You usually sign a blanket easement over your entire property, but it's not supposed to affect your entire property. Best example is for a utility. Say the power company wants to build a power line, or you want them to build a power line across your property to get to your house or to get to a neighbor's property. The legal description is going to be your whole property, but they don't really have an easement over your whole property. It's for the purpose of constructing a power line. So that power line is where the easement is actually located after it's built. And that's one reason why it doesn't have a legal description often at first, because maybe they don't know exactly where they're going to build the power line, but you're giving them the right to build it basically wherever they want to. Now, power companies often get surveys done and get exact, precise easements, but it's still common in rural areas, and it has been common for a long time that these blanket easements are out there. And so the legal doctrine has changed in that in the early days, a blanket easement was intended to be, Georgia Power says, I've got an easement over all your property. They built a power line, everything was fine, but then they might want to build another power line and not compensate the owner. They said, we've got an easement over your whole property. So there have been court cases that have defined, no, those blanket easements only actually pertain to the purpose that they were for. So you sign a blanket right-of-way easement to the power company in 1990. They finally come around in 1992 and built the power line. That's where the power line easement is for that blanket easement. It's not the entire property. They want to come back in 1999 and build another power line. They need another easement. They need to negotiate with the property owner. In an easement, there's two parties. The dominant estate is known as the party that has the right to use the easement over the burdened property. The servient estate is the burdened property. It's the property that the easement lies on top of. So if I grant an easement to the gas company to lay a gas line, I'm the servient property. My property serves the easement. It serves the gas company. The gas company is the dominant party. They get to come have dominance over that portion of my land and lay a gas line. Similar but different from easements are licenses. You may have given licenses before and didn't realize it. This is not talking about a driver's license or a firearms license. A license probably comes from the same word back in time, but it means the right to do something, a permission. But it's not recorded always, or at least it's not recorded like an easement, and it's not permanent. That's the primary distinction, is licenses are temporary, easements are permanent. A license can be verbal because it's not permanent. It doesn't actually affect real property unless you want it to. So I can, Frank can say, Bill, you can cross my property. You want to go cut timber on your property, and this is the best way to get it out, I will give you permission to cross my property. So that road that Bill uses probably needs to be shown on the survey. Is it prescriptive? Is it permissive? Is it a license? We don't know. Surveyors are just required to show possible easements, possible rights. There is one. Now, it's important to know that a license is a permissive use, and so it's not hostile. Bill can never come back and claim a prescriptive easement over Frank's land because his use is permissive. It's not hostile. Subdivisions could just be divisions, but legally we put the prefix sub in front of it. And that's just where we're dividing one parcel into one or more parcels, or dividing something off of it. It could be as simple as a 5-foot strip sold to the county to widen the road in a right-of-way deed that subdivides the parcels. The more common association would be, a big development with a fancy entrance and a tennis court. That's also a subdivision. How a property is surveyed or is subdivided has profound impacts on how surveyors are to subsequently survey those new parcels. So an original tract is not the same as a parent tract, but it can be. An original tract is just the way it was originally deeded out from the state or the federal government. It might be a square land lot. In western states, it might be a square section or a rectangular half section or a quarter section. In the colonial states, a lot of the property, most of the property came out by old, ancient, archaic metes and bounds descriptions of thousands or at least hundreds of acres. So those are original tracts. That's a term that's important to know. Starting with the original tract, as properties are sold off, if they're sold one at a time by a legal description or a survey of some kind, then they're in sequence. There's a sequence of events just like the chain of title. Different within a sequential conveyance, you'll have junior senior rights. So the first party has everything that they're supposed to have. And if there's not enough left, this first party is senior and it gets it. So for example, if a legal description says the eastern 50 acres of a tract of land, and then they sell the western 50 acres of that 100-acre parcel of land. And then it's determined there was only 95 acres. Well, the first tract out got its 50 acres because that common grantor had 95 acres to sell. So they sold the easternmost 50 acres of that 95 that they thought was 100, and that person has senior rights. Now, the second person that bought the western 50 acres, they actually only bought the western 45 acres. Some people that don't understand this concept, even attorneys, will say that 5 acres is disputed or overlapped. It's not. It's that first entity, that first person's property, because they have it by senior rights. Recognizing senior rights is very important in establishing boundaries where there's any kind of question. Then there's simultaneous conveyances that are different from being sequential. This is basically a subdivision plat where all those lots and all those right-of-ways and all those common spaces and green belts are shown on a subdivision plat that's recorded. Poof, at that one instant in time when it's recorded, all those parcels are deemed to have been simultaneously created. Now, they'll be deeded one at a time by the developer, but they're not construed as a sequential conveyance. They're deemed to have been created simultaneously, and they're treated differently. Just like the implied easements that come along with it, if there's a deficiency in those lots, like they're supposed to be 50 feet wide, there's supposed to be 4 of them in a block, that's 200 feet. If it turns out that that's actually only 198 feet, those lots would be prorated to everybody has equal. Everybody has 49 and a half. Or if it's 202, everybody has 100 and a half in the absence of original monuments. So simultaneous conveyances have different legal rights that surveyors need to be aware of, and we'll discuss those more in boundary resolution.